It's 7 minutes to 5 o'clock and breaking news, and it's actually a developing story. It broke earlier, the arrest of the Deputy Chief Justice Philomena Mwilu, which happened just after 2 p.m. this afternoon. Well, she has since left the DCIs and is now at the Millie Law Courts, where she is going to be read out her charges, which were earlier laid out by the Office of the DPP earlier on. And there are a range here of charges and live pictures that we can start showing you right now of her in court, I believe, here with her counsel, going over what they can expect for this court session. We can listen in just a bit before I go over the charges that have or are being investigated against her, and that is why she is now in court. That is the Deputy Chief Justice. A bit of a sticky picture here and there, but this is a live signal that we're getting from the Millie Law Courts, and I'll have a bit of some perspective from our legal officer here at the Nation Media Group, who can give us what to expect, can tell us a bit of what to expect and the scenario that might likely play out this evening. Perhaps there being a bit of a nervous smile there from the Deputy Chief Justice Philomena Mwilu. And yes, earlier on we had the DPP say that the evidence in his possession reveals that the Lady Justice Mwilu abused her office for personal gain, and that apparently accepted a gift in the form of money in circumstances which undermined public confidence in the integrity of her office. And also she is facing charges of obtaining execution of a security belonging to Imperial Bank Limited, now in receivership by false pretense. Holistically, of course, the charges that she has she faces the charge of abuse of office, and some of the evidence that the DPP is pursuing with this is unlawful failure to pay taxes, conducted herself in disregard of the law, and in view of the above, that is why they have concluded the evidence is sufficient with a reasonable prospect of conviction, and it is in the public interest that the criminal proceedings should be preferred. And we can listen in a bit as I introduced Seku Owino, our legal officer here at the Nation Media Group, to tell us a bit of what is playing out right now, given the happenings earlier in the afternoon. Seku, karibu to this. Thank you for joining us on short notice. You've been following it, of course, the arrest earlier, and now she is in court. What is seemingly playing out here, and is it perhaps an effort to have her face the charges and get bail?
Yeah, I think that's what's happening.
Yes.
It looks like she will be charged today, so probably what's going to happen is that the charges will be read, she will plead. Presume she probably will plead not guilty, and having pleaded, will apply for bail, which then the court will consider before it proceeds. I mean, today I don't think much will happen other than the charges will be read. We'll then get to know the details of what it is, because even as the DPP put them, they're still very scanty.
Okay.
Simply, we will get to know the details of it. The dates, for example.
Yes. Sorry.
I'm not sure myself whether these were committed after she had taken office of Deputy Chief Justice or before.
Yes.
That will then get to be known, and then we will begin to understand the timelines. Possibly then the court will look at them and the nature of the gravity, consider bail, grant it or decline it. Though I expect she will be given, I don't see why she shouldn't be.
Is there a time pressure in terms of getting her to court today, because it seemed very rushed after the arrest, and then she was processed at the DCI and then whisked right to Millie courts? Is there pressure here time-wise?
Yes, I think we need to understand what's happening today is what ought to happen. Because the Constitution, first of all, requires that when criminal proceedings are started, they need to proceed with speed.
Yes.
So you have your right to bail. When you're arrested, if you're arrested, I don't know whether she was arrested or she had been summoned to go there and record a statement.
She was arrested earlier in the day.
Okay, so if she is arrested, then you see the law requires that you must be presented before a court within 24 hours. So time is already beginning to run. It's already run. We're probably half a day out of it. So this is generally how it should be done.
Okay.
But, criminal proceedings need to be processed fairly quickly. And more so at this stage, because her liberty is at stake.
Yes.
If there's no reason why the court should hold her, or why she should be held in custody. She ought to be released.
So it's not playing to the gallery, because earlier people were saying this is, to protect her and out of respect for the DCJ, not to have her, spend the night in jail.
Nobody ought to spend the night in jail. I don't know why we enjoy this thing of saying so-and-so spending another cold night in jail.
Yes.
The Constitution gives everybody the right to whatever. So I actually applaud this, that this really is the standard that we should apply every day, that when somebody is arrested, by the time you're being apprehended, the charges against you should be framed, they should have been drafted. You ideally should even be told, why don't we meet in court, you plead to the charges. Okay. Then if they wish to oppose bail, at that particular point, they do it and the court makes the decision.
Okay. Yeah. In a few words, the DPP said, Nuruddin Haji said earlier that, she is faced with a charge of, abuse of office, but then lays out some of the evidence that they claim to have in their possession, and that is why they feel that, there's reasonable prospect of conviction in this particular case. When you hear these, and I'll just read it out, this is from their statement, that Lady Justice Mwilu abused her office for personal gain, accepted a gift in the form of money in circumstances which undermined public confidence in the integrity of her office, obtaining execution of a security belonging to Imperial Bank Limited, now in receivership by false pretense, unlawful failure to pay taxes, conducted herself in disregard of the law. Why did you say these are a bit sketchy?
Because if you tell somebody that you've abused office, or received a gift, the question then is, did you receive a gift from parties to a case you were hearing, or you just received a gift from somebody? She may have gone to a school and received a gift,
yes,
and maybe didn't declare it. So you really don't know what really the constituents of the offense are.
Yes.
So, because depending on the circumstances, if it's from a party, a litigant, to a case, then that's a different thing altogether.
Okay.
Yeah, okay. The gravity certainly intensifies.
Yes.
But if maybe all you did is you received a gift, and here you're now speculating, and maybe just didn't declare that you received the gift, and then if you're supposed to declare it or perhaps surrender it to the judiciary, you instead took it home, then that's a different thing. Mm-hmm. But the level of malfeasance there, if I can put it that way, is not the same.
Okay.
Yes.
And of course, this is not what's going to play out today in court. As you've said, she's going to have the charges read out to her, and then she'll plead guilty or not guilty, and then apply for bail. And you've talked about some of the issues, that the evidence that they claim to have against her, a bit sketchy. But the issue of failure to pay taxes, is that a heavy one?
That's what I also want to know, because not paying taxes generally is not a question which normally ends up as a criminal trial question.
Okay.
What often happens is that the tax authorities, when you submit your tax returns or you fail to submit your tax returns, they come and assess and they say, Seku, you have underdeclared your income for year 1, 2, 3, and 4.
Yes.
This is what we charge, and they normally charge a penalty for the failure.
Yes.
So this is quite unusual, I must say, for somebody to be brought to trial for a criminal offense of failing to pay.
Yes.
So then it should either be that the magnitude is so huge, it's been over a long period, or she's even been told you need to pay this and she's refused. So that's why I'm saying we need to hear what exactly this is about.
Yes.
Yeah.
And at the point of communication, by the time they have, what does it take for you to have enough grounds to feel that she can be arrested? They claim this is enough, normally.
Yes, they probably have it, and that's why I would want to see it.
Okay.
They probably have it. It's just that because you had to address and explain the country and explain why they were doing this. The context of it. To be fair to them, we're not saying that this is necessarily means that their evidence is lightweight. It's just that the manner in which they describe it doesn't give me, in all honesty, an opportunity to actually say what exactly is she being charged with. Just to underpin it against the facts, dates, and the circumstances.
Okay.
Yes.
I figure here what we're seeing is, some deliberations and just comparing notes there. I can see James Orengo, counsel James Orengo there. We will likely just have a short session here, but after the charges, and perhaps let's say the scenario where she pleads not guilty and in all likelihood given bail, then what plays out?
At this, okay, now then we go into the trial proper now starts. At that particular point, the DPP, and that's when we will get to know, because that's the point at which the DPP is required constitutionally to now give her the evidence. Disclose to her and to the court the evidence. And so she'll be disclosing his witnesses rather, the evidence, these charges we're being told the security she supposedly acquired, the taxes that she supposedly didn't pay, and the magnitude of it, to say, look, you're supposed to have paid taxes of X million shillings or X thousand shillings, you failed to pay it, and that, so that she again gets to understand it, to be able to prepare her defense.
In terms of her team being able to put a case across for her. Yeah. And I mean, depending on what is presented in court and perhaps what seemed to be admissible or not, then would this drag out for some time, depending on the nature of it?
I hope it doesn't, because what is at stake is quite huge. You know, we have the deputy head of a department of government. In my respectful view, some people don't believe I'm actually a believer in the equality of all arms of government. She stands in the same position constitutionally as the deputy president. It's like bringing the deputy president to court. So you cannot drag this too long.
Yes.
You can't drag this thing too long. I hope this is a trial that can even start next week or the week after and proceed very quickly. Okay. So that it's concluded as soon as possible. And then we determine, because it also determines her fate as to whether she continues holding the office of judge.
That's the thing that I needed to ask. In terms of her capacity in the office she holds, facing these charges, what does that mean for her post?
Yes. What it means for her posts, in ordinary circumstances, you would expect her then, and that will be left, I think, to her conscience. Yes. To then resign. Or step aside, and depending on what we call step aside, she may say, look, I will not perform my functions as judge, but I will not resign pending the hearing. Because we must remember, the law presumes everybody's innocence until proven guilty. Yes. So she ought to, ideally, still hold on to that office. Okay. Maybe not perform the functions, but remain there because until the trial is completed, yes.
It wouldn't be seen, or would be seen perhaps in some quarters as some form she could use her clout in any particular way as a DCJ to, you know, influence the case.
To influence the case, yes.
Yeah, the case that she is now going to be engaged in. Yes. But in terms of, you know, the presence of the Supreme Court and its makeup, does this affect in any way?
No, it doesn't, but it means then that the Supreme Court quorum, what we call the number of judges who sit to hear Supreme Court matters, will be fairly tight because there are only 7. Yes. Now, if she's unable to hear cases going forward, that means there'll only be left 6. But of course, the law says that any 5 Supreme Court judges can sit and hear any matter substantively. Okay. So it doesn't affect it. It only just means then that the others will have to do a little bit more of bearing of the load that will otherwise be held by her. Okay. And then the administrative duties which she performed on behalf of the Chief Justice as required under the Constitution, because he can delegate some functions to her. They may have to go back to the CJ, or depending on the position they take, he may delegate it to another judge within the Supreme Court to perform them during the period of her absence, while she's being tried.
But in terms of knowing that this case will go forward without any interruption, even though she is a DCJ facing such charges, is there any remote possibility that there could be interference and influence to this?
I can't tell. Let's face it, this thing is going to be a test, not just of the judiciary. It's going to be a test of our Chapter 6, which we've messed up quite a bit, and that's the problem with it. And it's also going to be a test of our fidelity to the Constitution, as we've always claimed to be. Yes. We are in the 8th year. Yesterday was the 8th anniversary of the Constitution passing, and then we have this kind of thing. It will be a fairly big thing, and depending on how it plays out, it will test the Constitution quite a bit. Yes. Because, Mark, my view has been that people operate differently, but my view has been, and I think there is wisdom in the thinking that probably this would not have been the way to go, and I'm not second-guessing the DPP. I would probably first have taken these complaints to the Judicial Service Commission, have a tribunal formed if the Judicial Service Commission takes the view that the charges are sufficient to warrant a tribunal being formed. Okay. Because then when the tribunal is formed by the President, the Constitution then says she steps aside. Yes. In these circumstances, there's no requirement for her to step aside. Indeed, we have precedent of fairly senior state officers, no less than the President, and dare say, and his deputy, facing charges but remaining in office. Yes. So, and many, many more have had. We've had governors being charged, and they remain in office. So, on what basis then are we going to be telling the Deputy Chief Justice that she ought to step aside? She will say, yes, I will not perform my functions for the time being, but I will not resign. I will await the outcome of the trial. Okay. So then, though of course then you say, from a perspective of trying to do things neatly, it isn't quite neat in the ideal sense. Because, as people have rightly pointed out, you have here the second highest officer in the judiciary, facing being tried by a judge. I mean, it's like, I don't know, in my mind, it's just like having the managing director appearing before a clerk somewhere in disciplinary proceedings. It's a bit untidy. Though, of course, we know that the judges and the magistrates, judicial officers generally have taken an oath, therefore, to administer justice without fear or favor, ill will or affection. They are still human beings, and that plays out. And even then, in the face of the public who are supposed to be seeing justice as being done and being seen to be done, it always raises a question mark. That's why that issue will be there, and it will remain with us until this trial is over.
And even earlier in the newsroom, someone asked, so she will come before a judge who's a junior, perhaps.
Yes.
And I mean, how does that really play out? But legally, this is protected in terms of, going forward concretely with this case.
It should be.
Nothing will compromise it.
It's not expected to be compromised. I mean, while she's there, she's just an accused person like any other person will be accused. She has all her rights of presumption of innocence. She has a right to get to know what the case against her is. She has a right to bail like everybody else. And that will be there.
Okay. And you mentioned the channel of the tribunal, which in your view would have been, neater prospect.
Yes.
But wouldn't that have been seen as, somewhat protecting? Like if she has any criminal charges against her, she should face it like any other Kenyan. Wouldn't have that been seen as treating her in a special way?
That's a requirement by the Constitution, because not every Kenyan is taken through that tribunal. This tribunal comes by virtue of the position she holds in the judicial. In the sense that you say, because frankly speaking, if these charges against her are true, and if she's convicted of them, there's no way she can continue holding the office of Deputy Chief Justice.
Yes.
Okay? So then the thing would have been, because they are essentially, if they are true, they are misconduct of a very, very high and egregious level. So the easier thing would be then to go to the Judicial Service Commission and say, this is what we have against the Deputy Chief Justice. Please investigate it. And if you think they warrant charging her at that particular point, the tribunal is established.
Let's listen in. I believe the judge has entered, and we can listen into this session now.
Please, Your Honor, my name is James Orengo. We appear on this matter for the defense, together with senior counsel, Honorable Omogeni, Dr. John Khaminwa. I'm present, Your Honor. Maanzo, present. Is Julie Soweto, present. Mr. Jackson Mawere, present. Mr. Edward Wasso, present. Ms. Josephine Mangare,
present too.
Ms. Haley, present. Ms. Caroline Kamal, Honorable Millie Odhiambo, Honorable Peter Kaluma, Honorable Anthony Oluoch, and Honorable Mutula Kilonzo Jr., who was around with the shop. For the prosecution, Ms. Okongo is here, or probably I'll leave it to you. Yeah, and then there's for the second accused is Mr. Morris Kimori. President, I'm sorry. I'm so sorry. Just that
I was waiting for the senior counsel to see.
As you can all see, we already passed
May I please go on record, Your Honor? I requested to introduce myself on my team. May it please, Your Honor, my name is Dorcas Oluoch, Secretary of Public Prosecutions, and I appear together with Ms. Millie, Deputy Director of Public Prosecutions, Ms. Okongo Christine, Senior Assistant Director of Public Prosecutions, and Mr. Odhiambo, Principal Prosecution Counsel. I also note that it is past the gazetted time for the court, and therefore we wish to have directions from them.
It is now past the court sitting hours, already 5:15 p.m. This court directs that this proceeding shall be adjourned.
Yes. Your Honor, we are quite comfortable with those directions. But our client has been brought before the court as an arrested person. And the applicable law would be Article 49 of the Constitution. And unless there are compelling reasons why she should not be released on a pastoral recognizance, the constitutional dictate is that she should be released until the next session of the court. We were going to address, Your Honor, very extensively on constitutional issues in relation to the charge. Before plea is taken, we do not intend to cause any delay. But it is a right which we are going to demonstrate that a challenge to a charge or a plea is not only a jurisdictional question, it goes to the jurisdiction of the court, but also the constitutionality of the proceedings. And there are authorities that were going to cite that such objections should be raised at the earliest opportunity before plea is taken. That being the case, despite the fact that
Senior counsel there, James Orengo, part of the defense team, just trying to make a case to be able to apply and get bail for their client. That is the Deputy Chief Justice Philomena Mwilu. Bit of a challenge there with the sound, but we still have, we could listen in. Sekou, you've been following this with me, and from your legal background, what is playing out right now?
I think they're trying to get, because from what you can get, the magistrate, the judicial officer has decided that since it's outside time, why don't we come tomorrow?
Right.
Okay, so they're trying to make sure, Mr. Orengo is trying to make sure that instead she's not held in custody overnight until tomorrow.
Earlier we thought that it's no concern if it's past 5 p.m.
Yes. The judicial officer has the discretion to hear it, to extend the time or not. So in this case, he seems to have decided, come back tomorrow, it's after 5. And so they're trying to make sure that she does not spend the night in custody.
But then again, earlier you told us that if someone is arrested, then you are presented before court and there are no charges or there's no reason, compelling reason to hold you, then you should be released on bail.
Yes.
It's your right.
Yes, that is true. Bail is a constitutional right. Whatever the charge, you're entitled to it, unless there are compelling reasons for you not to be granted. The presumption is that everybody gets bail unless there's a reason not to.
Right. And I mean, here it seems that the judicial officer isn't too convinced from what the defense team is, presenting before court, is really trying to plead for her case to be granted bail. So, as you still, had said earlier, it's the discretion, full discretion, and he can't be swayed in any way. In terms of what the defense...
I think what he's saying is that, look, why don't you just bring this thing, including the bail issue, tomorrow, so that we hear it tomorrow. That's what appears to me to be the case that he's trying to say.
And if that's...
But they're trying to make sure that that doesn't happen.
Because, I mean, you'd know the statement
Yes.
this would make, that the DCJ has spent the night in jail, and that in itself is... but, for instance, now if he doesn't, sway and change his mind about the bail application, then obviously...
she would have to spend the night in custody and be brought back to court tomorrow.
Right.
To then take plea.
And then that would be to start, and then the trial proper would start a bit later.
Yes, and possibly the bail will be argued tomorrow if he does not allow them to do that today. The other alternative is that he could hear them today and then reserve ruling, a decision for tomorrow.
Okay.
And then have that.
I mean, someone might think, for an officer such as a DCJ, you'd want to have, as you said earlier, neat, play out of this.
Yes.
Not in terms of favorable treatment, but just have a neat play out of this case. And this is, would be somewhat messy.
And that's probably the pressure that is going to play out throughout this, because then everybody will be looking and thinking, is the DCJ getting special treatment? Maybe that's what's playing around in the mind, and saying, look, if it was everybody else, if it was a Sekou who'd been arrested at 5 o'clock and brought to court, he'd have been told, go and it's after time,
right?
It's after 5 o'clock, just go back to custody, we'll hear your bail application tomorrow. And then you'd have to live with it. So I get the balancing act that the judicial officer here has to be careful not to be seen to be swayed by virtue of the office of the person appearing before him.
Right. We have the audio back. Let's listen in.
At 1. He stayed at the DCI offices until late in the night when he was taken to Muthaiga police station. He was fished out of Muthaiga this morning, and I was with him from 8 a.m. until now. And therefore, Your Honor, my submission is the fact that he has been brought here at the wee hours, at the late hours of the day, has nothing to do with himself. In everything else, I associate myself with my learned friends.
May it please Your Honor, with tremendous respect to my senior Mr. Orengo and all the advocates, may it go on record that although the first accused person is the Deputy DCG, the Deputy CJ, and the second accused person is an advocate of the High Court of Kenya and an officer of this court, they are appearing here this evening, afternoon, evening, in a different capacity. And that is the capacity of an accused person who has been arrested. And therefore, should the court be minded to grant that application, conditions other than personal bonds would be necessary. And secondly, it should be very clear that those conditions and the bond will only apply up to tomorrow, 9 o'clock. Thank you.
Let me ask, then why did you have to bring them this afternoon?
To comply with Article 49.
Your Honor, we all intended to bring them earlier, but I wouldn't go into what happened, but we all intended to be here early and the charges were registered earlier enough. We would have done it in the morning, but we started this yesterday.
In a way that is disadvantaging the accused persons, which is not right.
Thank you for the much.
The state has brought the accused persons to court way past court working hours, and this in a way prejudices the accused persons even if the court was to grant them both with sureties or conditions. At the moment, the court offices are closed, banks are closed, hence to grant any board with terms at the moment will be akin to denying the accused persons bail. Consequently, the court orders that pending any further proceedings that will continue tomorrow, each accused shall be released on executing a personal bond of Kenya shillings 5 million. They are further ordered to appear before this court tomorrow without fail at 9 a.m. These terms are temporarily to secure their appearance tomorrow, and after tomorrow's proceedings, the court shall, if necessary, impose such further conditions as it shall deem necessary.
Is it possible, now that the office has the execution of the personal possession?
My court assistants are here. They will prepare the forms.
The court session is over, and as would have been anticipated, at least what Seku had earlier said, the most likely scenario is what has played out today, but some back and forth between the defense and the prosecution.
Yes, there is. There's been some back and forth. The prosecution brought them, and they're saying it's late. Of course, the defense are saying, look, if we are to apply for, if you are to leave them and go to trial tomorrow, ask them they'll spend the night in custody.
Yes.
It's not their fault. And the judicial officer rightly saw through that and said, look, even if I was to give them bond today, under the normal terms, okay, what often happens is that after you're granted bond by a court, it is processed. There's a process of verifying the sureties. So like if, for example, I say I'm granted bond of 5 million with a surety of $1 million, and I bring in Mark or somebody, the court has to check, does Mark really have 1 million bob to stand surety? It's not just a question of signing papers. Okay. It's a family. Now, because it's after 5, that is not possible. And until that is done, you are held in custody. Yes. So what the judicial officer has rightly done, and I'd have to commend him for such grace under pressure, because there's a lot of pressure you can see from this. There's the pressure on those who think, oh, he's going to be lying down to his bosses, his boss in the judiciary as the Deputy Chief Justice, and therefore letting her go easy. And those who are also going to be saying, look, he may be trying to show that he's tough by denying the bail, or the prosecution coming to say that he's less than even-handed. He said, okay, let me give them personal bond. Just a personal bond is just the personal one that you give by yourself, so each of them signs for 5 million shillings. Yes. Then until tomorrow, 9 a.m. So then they can go home. Okay? They don't have to be held in custody.
And what will play out 9 a.m. tomorrow?
So tomorrow, they make the substantive bail application.
Okay.
After the charges are read. So the charges will be read tomorrow in court, then they make the substantive bail application. At which point then, I think the judicial officer will probably review the terms of the bond. He may then require further sureties or something of that kind, because he said at that point I will consider whether further conditions are necessary on their bail applications.
All right, and you've mentioned there, you know, just tomorrow it's just perhaps reviewing, but then there will be the charges read in court. Yes. Those are the charges that then the prosecution team will hand to the defense team. Yes. That will
plus the evidence.
Plus the evidence that they claim to have on this. Yes. And that perhaps will start the process proper for the trial. And you'd say there's no definite, there's no saying right now when the trial proper would start.
Yeah. Most likely they'll after tomorrow, after they've disposed of the bail application and the plea is taken, the court will then set a date for the hearing. At that point, then they'll have to look at coordinating their diaries. There's a constitutional requirement that criminal trials be as expeditious as possible. Right. There should not be undue delay. So most likely the court will consider its diary and the advocates will consider the diary. If they coincide, then they fix a date.
Right.
Yes.
And I mean, there's no, you see the senior counsel, James Orengo, and the lineup of those who are there. There's no reading into the makeup of the team in law. I mean, they come in as lawyers.
Yes.
Regardless where you're perceived to be.
A person is entitled to advocates, to be represented by an advocate of his choice.
Yes.
And our reading of that in law is then that it doesn't have to be one advocate. It can be 100 advocates, if you can afford it, or if they are willing to provide the service pro bono.
Right,
yes.
right. All right. I believe, this, with everything that has played out, and you've said earlier that you, from what has been given as supposed evidence by the DPP to really go to conviction on this, it's still sketchy. We would really be able to talk about this when we have, in terms of the weight of this case, when we have the charges read out tomorrow.
Yeah, when we read the charges, they'll say the dates on, between these dates and these dates, she did this and this and this. This is how she, because they're saying she obtained a security by false pretenses. Then we'll even get to know what is the security. We know it from Imperial Bank on the basis of the statement by the DPP. We'll got to know what is the security that she supposedly obtained by false pretenses, and what exactly did she do it, and what are the dates on which this is done. Yes.
But as is from now, in the terms of the charges that have been stated in perhaps a few words, abuse of office and
tax evasion,
that's not specific enough to really say how this case will play out.
You can't tell it at this point.
All right. Yeah. With that, Seku, as you've said, you commend the judicial officer with the wisdom that he's applied here in deciding to give them personal bond of 5 million shillings. But then they say that from 9 a.m. tomorrow, there will be now a session where they would now hear the bail, application and probably review and then hear the charges read out to. And that's when
I think they'll start tomorrow with the reading of the charges.
Yes.
Then they'll plead to them, guilty or not guilty, after they have. Then at that point, bail application is made.
All right. Yes. Thank you very much. And Seku, for your time. Short notice as was, but you've given us some good scenarios to anticipate what would play out from tomorrow morning, 9 a.m., when the charges will be read out, and then they'll plead to whether being guilty or not, and then we'll see how it plays out tomorrow. And this is something that will definitely dominate our news programs at 7 o'clock and at 9 o'clock. But as of now, the accused who arrested the DCJ and the advocate free. They have gone home and will be back to court tomorrow 9 a.m. and we'll definitely be covering all this live and giving you the latest update on it. For now, we get back to normal programming. We'll be back with the 7 o'clock news. Join us then.